Welcome everyone to our Dentons Academy, the initial one for 2025. We're going to cover some housekeeping issues at the beginning here, and then we'll launch into the content. So everybody who is attending, your lines have been muted. If you have questions, you can enter them into the Q&A space, and we'll answer those as we go. If we don't get to any questions, we will follow up. We are recording the webinar today so that if anybody couldn't make it, they can watch it on a delayed basis. If they have questions, please feel free to reach out to the presenters, and we'd be happy to follow up with you. We can only provide CLE, though, to folks that are attending the live broadcasts. So, that's one caveat. And then another important note, if you're in New York or New Jersey, licensed in New York or New Jersey in terms of your bar license, please listen for the code word. And when prompted, you're going to need to enter that code into the Q&A section of the screen. If you don't have a license in those jurisdictions, then you can disregard that. So with that, we'll launch into the session. If you could advance to the next slide, please. This provides the agenda of what we're going to cover. We're going to get into case law developments in the various topical areas here, and we're going to share presenting duties across a number of great Dentons colleagues in the Government Contracts Department here in our Denver office. So looking forward to the session today. Next slide, please. So we're going to start with contract interpretation and delays. We have 3 cases that we'll be discussing on that subject, and I'll be your first presenter. So the first case comes out of the Armed Services Board of Contract Appeals. It was decided about the middle of the year last year, and it involves a commercial product contract for the delivery of portal cranes to the Department of the Navy out in Washington State. And again, this was a commercial product contract, and really the first time that the Navy had purchased what are called level luffing cranes. And so initially, when the contract was being negotiated, there was some discussion about, well, what specifications and design requirements should be included in the contract, if any, that would vary from the contractor's standard commercial product level luffing crane that would meet the requirements of the contract. And the parties ended up agreeing to include certain industry standard terms in the contract. And the contractor provided a design. The only adjustment to the design was that the Navy wanted some walkways that would go along the boom arm of the crane. The boom arm of the crane is kind of the long section that juts out from the cab, or the center part where the operator is sitting. And so the contractor was working away on the first crane that was going to be delivered. And as part of that, the Navy had an inspection that they came out to do. And when they looked at the crane before it was delivered, they noticed that there was quite a bit of corrugation wear on the level luffing drum, which is a part of the crane that raises and lowers the boom arm. The Navy expressed concern about it. The contractor looked at the damage and agreed that it was unacceptable, and looked into root cause. And ultimately, the contractor concluded that the root cause of the issue was actually the wire rope that was being used, and proposed to substitute a stronger wire rope that would be smoother, and so it wouldn't cause the corrugation damage. And proposed that as the fix, which was a relatively simple fix. The Navy disagreed and said, nope, I need you to use a steel hardened level luffing drum instead. And so the dispute really centered around whether or not the Navy's direction to substitute a steel hardened level luffing drum was essentially an attempt at a change. And if the contractor didn't agree, then therefore a breach, or if the contractor was obligated to comply with the Navy's instruction. And based on a hearing at the Armed Services Board, the board judge decided that the contractor had complied with the contract's unambiguous requirements for the level luffing drums based on the industry spec that had been included in the contract. The contractor had an alternative argument that, the government had essentially constructively changed the contract by ordering them to implement the level luffing drum change. And the board said, look, this is a commercial product contract, and under FAR 52-212-4 and the other terms and conditions, there are not terms for stop work orders or government delay or suspension of work that might have provided equitable adjustment avenues for the contractor. Instead, the appropriate way to view what the Navy had done in this case was a breach of contract. And so the board ultimately awarded the contractor a part of the damages that they had been seeking. The contractor was originally seeking about $17 million, and the board awarded 4.9 in delay-related breach damages because the Navy had breached its implied duty not to interfere with the contract and had adopted an interpretation that was contrary to the contract requirements. The contractor wasn't able to recover the other part of its damages claim because those related to estimated future costs that the contractor hadn't yet incurred. The contractor is going to have the opportunity to pursue those down the road. The most notable takeaway from my perspective for commercial service contractors is that while you might in a typical government contracts case think of things as constructive change theories, it's likely best in the commercial product context to initially approach those as breach theories and hew closely to 52-212-4, which contemplates that the parties have to bilaterally agree to changes to the contract. And so the concept of constructive change is a bit of a square peg in a round hole in most cases. Next case, please. So this is a CBCA decision, and in this case, the contractor had received a requirements contract from the VA to provide home oxygen services. And the dispute in this case really centered around basically what ended up being a discrepancy between what the VA had estimated would be the requirements when the proposal was issued and the contractor was preparing its proposal versus what the government ended up actually requiring during the contract. The government ended up ordering a lot less home oxygen services than the contractor had anticipated, so they were seeking a price adjustment. So the contractor's initial, sort of theory of recovery was that if the government enters into a requirements contract, it's important that the government provides a reasonable estimate to the contractor as to what the requirements are going to be. And if the contractor can establish that the estimate was defective or negligently prepared, then the contractor has a potential avenue for recovery. And in this case, the board looked at the facts and circumstances and agreed with the contractor. We have a negligent estimate. The estimate was flawed for a number of different reasons. But the contractor's case fell short because it wasn't able to establish that it relied on the negligent estimate. The reason the board got to that conclusion was this contractor was the incumbent. Much of the data that the government had relied upon to prepare its estimate was contractor data, and the contractor could have, according to the board, seen the discrepancy between the data that it had and what it was showing was likely the requirement versus what the VA had published. And because the contractor didn't bring that issue up in advance of the contract being awarded, that was kind of, from the board's point of view, a patent ambiguity, and it was waived if the contractor failed to bring it up in advance of contracting. This kind of gets to what we see increasingly as a bit of a trend with contract disputes where if the contractor sees an issue pre-award but fails to bring it up, you run the risk of waiver. Now, what that creates is a stronger incentive for contractors to pursue protest type activity before the contract is awarded to try and suss out and resolve any of those issues. So we'll see if these types of cases in this vein, where there's a question about the appropriate contract interpretation, are going to cause more contractors and their counsel to think that, well, we got to go the pre-award protest route. Otherwise, we're going to have a real issue potentially down the road. It's all sort of trying to predict the future and speculate. Many contractors don't want to get into those fights with their potential customer at the front end. But the risk is that if you don't deal with it, you're potentially going to be found to have waived the issue. So that's the takeaway from the Commonwealth case. Let's move to the next one. So the last case that I'll be discussing in the contract interpretation context, called Chugash Federal Solutions Incorporated. It's an Armed Services Board case, and notable because it's a situation where a contractor was able to successfully recover for impacts associated with the COVID-19 mandates. We've seen a number of other government contractors attempt to secure recovery primarily in the context of firm fixed price contracts, and they were unable to. In this case, this contractor was providing base operations and maintenance services at a number of far-flung locations out in the Pacific Ocean. And the government had, in connection with the emergency orders, the base commanders at these various locations had ordered that the contractor needed to have all folks that were coming to these island locations quarantine for 14 days before they could proceed with performance. So what that caused was, a fair bit of delay and additional cost to the contractor as well as some of its subcontractors. In this case, there was a contract clause, the AFARS clause, which provided an avenue for the contractor to secure, an equitable adjustment in the event that the government ordered something that would affect cost increases or delays associated with health or safety issues on government installations. And when the base commanders had issued the orders about quarantine and so on, the contracting officer had actually followed up and said, yep, I acknowledge that this potentially would be an avenue for recovery. So the contractor submitted an REA and ultimately a claim, and the contracting officer turned around and denied it and said, nope, I'm not going to give you an adjustment because this is a fixed price contract. And so the question presented for the board was, and part of the government's defense was, this was a sovereign act. I had no control over what the base commander was doing. And ultimately, the board found that the government failed to carry its burden on its affirmative defense of a sovereign act because it had failed to show that its performance became impossible by virtue of the sovereign act. And the reason it wasn't impossible was largely because there was this contract clause that specifically contemplated the equitable adjustment that was being sought by the contractor. So ultimately, this case is helpful in terms of, at least emphasizing to contractors, look, you got to read your contracts if you're going to pursue some sort of COVID relief in the context of a fixed price contract. You got to hope that you've got some contractual mechanism that gives you an avenue. Here, the contractor had that. It probably is somewhat limited in that sense, but may provide contractors with some insight as to how the board will resolve issues where the government's alleging a sovereign act's defense in the context of a contract interpretation dispute. So those are our contract interpretation cases. I'm going to hand it off now. If you'll flip to the next slide. Natalie, are you taking over?
I am, yes. Thanks,
all right.
Nicole.
Thank you.
So our second topic today is the False Claims Act. Nick, if you could advance the next slide, please. Thank you. So this case, the Zafarov case, a very, very impactful, kind of monumental case that was issued in September of last year. The reason why it's so kind of groundbreaking, at least in the FCA world, is because it's the first time a court has held that the qui tam provisions under the FCA statute are unconstitutional. And in this case, the court holds that the qui tam provision is unconstitutional under Article 2 of the Constitution. So this obviously is a federal district court case out of the Middle District of Florida. And often federal district court cases may not have such broad impacts, and especially as is the case here, where there are other circuits who have already adjudicated this exact issue and have actually come out, with the opposite conclusion. So you might ordinarily assume that a federal district court case may not have such broad impacts, but here, this case is expected to potentially change FCA litigation really broadly in the future. And in fact, we're already seeing some effects of that already since this was issued back in September. So just some high level kind of factual background of what was going on here. Again, this was a qui tam action, which under the actual False Claims Act statute, the statute empowers obviously the government to enforce and prosecute FCA claims, but it also empowers private individuals to prosecute and enforce the FCA. So as Judge Mizell, the district court judge who authored this opinion, as she really emphasizes, that's a very unusual part of the FCA statute, right? So this is the qui tam provision, and the individuals who bring these qui tam actions are generally like employees or former employees of the defendant, some type of insider with personal and specific knowledge about the facts at issue. So those individuals are known as relators, and these qui tam actions really make up a pretty significant portion of all FCA litigation broadly. And that makes sense, right? Because these insiders or these employees would just more generally be closer to the facts and be able to see potential violations of the FCA. So there, makes sense that these whistleblower cases are often brought by former employees. And also, obviously, the statute sets up an incentive since they can recover a portion of the damages. So it's really a significant portion of FCA litigation. And procedurally, this mechanism requires that the case be kept under seal and the government start its own investigation once this qui tam case is brought. And the government, after investigating, can determine if it wants to intervene or it can decline to not intervene. And if it declines not to intervene, the relator is entitled to continue on its own without the government. So this happens all the time. It's only about 20% of qui tam cases where the government does decide to intervene. And that's exactly what happens here. So here we have Clarissa Zafarov, who is a doctor. She's a former employee of the defendant here, Florida Medical Associates, I think. And she is alleging that they essentially have submitted falsified diagnosis data. So I'm somewhat simplifying it here, but basically she's alleging that they were lying about the health of their patients, saying that their patients were sicker than they actually were and were given treatments that cost more than they actually cost. So that's kind of the factual basis of her claim. And like I said, the government did not intervene here, so she continued on her own. And this case actually went on for 5 years before the government ultimately filed a motion for judgment on the pleadings. And that's where they bring up these Article 2 constitutional issues. So in their motion for judgment on the pleadings, they assert several Article 2 grounds for saying that the qui tam provision is unconstitutional. So they say it's unconstitutional under the vesting clause, unconstitutional under the take care clause, and then unconstitutional under the appointments clause. And the appointments clause is the one that Judge Mizell takes up. That's the one that she runs with, and that is what her decision is based on. And interestingly, the DOJ, like I said, did not intervene here, but they did, once the government files this motion for judgment on the pleadings, the DOJ files a like a statement in opposition to the defendant's motion, and essentially is arguing that this issue has already been adjudicated by several other circuits. So it had not been heard or adjudicated specifically by the 11th Circuit, but it had been taken up already by the 5th, 6th, 9th, and 10th Circuit. And so really the government's statement is focused on the existing precedent, saying, you know, this has already been adjudicated. This is not a new argument. You know, this should be an open and shut, easy case. They're really arguing to defend the qui tam provision. And the Judge Mizell obviously ultimately rejects that argument, right? And she grants the government's motion to dismiss. So the case is ultimately dismissed. It does get appealed. And the basis for the dismissal is that Judge Mizell finds that the relators in the qui tam provision cases are they qualify as officers under the appointments clause. And you know, she kind of starts broadly by describing executive power. And so there's this extremely sweeping and broad power to enforce the laws of the United States, and that's vested solely in the president. The president, she says, is the executive branch. And of course, the framers knew and contemplated that the president, as just one person, as a practical matter, would not be able to enforce all of these laws. And that's, you know, the reason that the appointments clause exists, right? So this is the clause that gives the president the authority to appoint both high-level officials or officers, and then inferior officers as well. So no matter which type of officer, they're subject to the appointments clause. And Judge Mizell kind of walks through this analysis, and she says to be an officer, to qualify as an officer, you have to exercise significant authority pursuant to the laws of the US, and you have to occupy a continuing position. And she says Dr. Zafarov clearly meets both of these requirements here. And since she was not appointed in accordance with the Constitution, this is unconstitutional. And all qui tam actions, similarly, where the government did not intervene, would also be unconstitutional under this reasoning. So in terms of why this is happening now and why we're seeing these constitutional issues kind of gain traction now, that's really based on a 2023 Supreme Court decision where Justice Kavanaugh, Justice Barrett, and Justice Thomas all specifically indicate that they would like to review this issue. So they say, you know, and it's the Polanski case where they write this, and it's in Justice Thomas's dissent where he says, you know, this is not at issue in this Polanski case, but we really think that the qui tam provision needs to be reviewed under Article 2. Justice Kavanaugh and Justice Barrett have a concurrence where they specifically concur with that part of the dissent. So all three of them have signaled that they want to review this, right? So, you know, we know that that appetite is out there now. Interestingly enough, 20 years before that case, in the Stevens case, which actually looked at whether a standing challenge could be viable under Article 3 of the Constitution, Justice Scalia wrote something like, they very much rejected the standing challenge, but Justice Scalia wrote something like, we are sidestepping and we are, intentionally not leaving open the possibility for a challenge under Article 2. So all these things kind of opened the door or created the path for Judge Mizell, who actually clerked for Justice Thomas, to kind of pull that thread, and now is the first court to find this unconstitutional. And in terms of impact, we have already seen some challenges in other circuits now raising these same arguments, and we can expect to see this in both intervention cases and non-intervention cases. And one interesting part, the Trump administration has said that it's going to continue defending the qui tam provision. Obviously, the 3 justices on the Supreme Court are super conservative, and then Justice Mizell herself is a Trump appointee. So it's interesting that they are taking this position, and some expect that they will not defend, but as recent as last month, they have said that they're going to continue to defend the constitutionality of the qui tam provision. So, this is something that I think we can expect to be brought to the Supreme Court within the next few years, either this case or another case. It's possible that even if the 11th Circuit reverses Judge Mizell's opinion here, that a different circuit could set up a circuit split. So really, really interesting case, and has the potential to impact future FCA cases really broadly. You can advance to the next slide, please. So the next topic is data rights and license agreements. You can move to the next, please. So this case, geospatial, is a COTSI case. This one's a lot shorter, I promise. So here, this is a case about patent and copyright infringement. It's a lawsuit brought against the government by a contractor for alleged unauthorized use of a contractor's intellectual property. And the fundamental disagreement here is what precisely must have been prepared for the 1498B provisos to apply. A file that was ultimately further developed into copyrighted work, or the new unique functionality of the copyrighted work. And so here the government filed a motion to dismiss, and then in the alternative filed a motion for summary judgment. The court denied both, finding that there was still a lot of material fact disputes. And the government also argued that there was, a lot of inaccuracies in the contractor's registration. And the court seemed pretty sympathetic to this argument. Like, they did say, there's some clear carelessness in the application, but the government didn't show willful blindness, or that they knew about the inaccuracies. So in terms of a key takeaway, I think that in itself is helpful, just to give some more details for the bounds of what's required to show that willful blindness. And then also just the ultimate outcome of this case will be helpful and insightful to show what's required to prove that these copyright infringement exceptions are met. And you can advance to the next, please. And I think I'm handing it off to Megan here.
Yes, thank you, Natalie. All right, we're going to go into one case that's kind of focused on technical rules that are affecting contractors when it comes to appealing issues to the board or the Court of Federal Claims. You can advance to the next slide. So we have this case, Platinum Services. It focuses on the Contract Disputes Act statute of limitations, which is a 6-year statute of limitations. But the reason why we're highlighting it, because that's kind of more of a not always as interesting of cases, but the reason we're highlighting it here is because the board's analysis of when equitable tolling of the statute of limitations is appropriate for an extraordinary circumstance. The background in this case is that the contractor PSI sought payment of 26 invoices to the Army under 4 contracts for provision of moving services. It's not disputed, no one disputes that that PSI provided the services invoiced. and that they sent the invoices and they never received the payment. So none of that is in dispute, but the board's order was in response to the Army's motion for summary judgment, arguing that PCI's claims were time barred by the Contract Disputes Act 6-year statute of limitations. It is clear from the facts that PSI's claims for a final contracting officer final decision did come more than 6 years after the last date it submitted any of the unpaid invoices. But PSI argues that the interactions between the parties during those 7 years should count as extraordinary circumstances justifying tolling or a pausing of the statute of limitations clock. So the background on that, so let's go into like the facts that will be helpful to determine is this an extraordinary circumstance that justifies equitable tolling? So here, PSI submitted invoices for services completed in 2011 and 2012. But in 2012, something happened. The Army's computers crashed, resulting in a loss of other relevant records that they would need to be able to pay the contractor. PSI and the Army exchanged extensive communications about the payment of contractor invoices, and the government assured the PSI that it was working to resolve the dispute. In 2012 alone, they exchanged more than 70 emails regarding the non-payment issue. 2013, it was 70 emails. Then in 2016, it was 130 emails. So there's constant back and forth happening. And at one point, the Army got the contracting officer more involved, and it led to a lot of the unpaid invoices starting to get paid. So there was improvement. There was the Army wasn't trying to say they didn't want to pay the invoices. They were just trying to find all the relevant records that they got that were lost in the computer crash. At one point, PSI was waiting on 1.2 million in unpaid invoices from that were at least 3 years old. So in 2019, so there was increased payment, but there were still, PSI was continuing to communicate to the Army that it had certain invoices that were still remaining unpaid all the way back to 2011. Despite the contracting officer's assurances that the legal team was looking into alternate ways to get PSI paid, PSI finally felt like there was no path to resolution and submitted a certified claim in 2019 that without dispute was more than 6 years after the claims accrued. So PSI tried to argue that because of all of this, the back and forth, the communications, then the Army started to pay for services, justified extraordinary action, which should relate in a tolling of the statute of limitations, because I believe that the Army induced PSI to hold off pursuing a claim. The issue here, unfortunately for Platinum Services, is that the courts and boards have extended equitable relief very sparingly. Typically, it's more permitted when a claimant has actively pursued its remedies, but it filed a defective pleading during the statutory period, or where the claimant was induced or tricked by an adversary's misconduct into allowing the filing deadline to pass. Unfortunately, here the board did hold that the statute of limitations period barred Platinum Services from recovery because they were fully aware of their claims. They are aware of when the Army's duty to pay was breached, and they knew all the events necessary to fix liability existed and established on the date of the accrual of that claim. And the Army's loss of relevant and needed data to pay the invoices due to that computer crash was unfortunate, but not unusual. The board said that the crash did not impact PSI's ability to submit claims regarding unpaid contract invoices, so it did not qualify as an extraordinary circumstance, which is usually when circumstances render critical information, reasonable investigation notwithstanding, undiscoverable. So the key takeaways here is that even if you contractors are in discussions and like productive discussions with the contracting officer or their customer regarding unpaid invoices, other related disputes and claims, make sure you watch that statute of limitations clock. And as soon as you start to get closer to that 6 years, you can go ahead and you can file a claim. You can submit a claim for a final decision, then bring a subsequent protective action and move for a suspension or stay of proceedings while further attempting to negotiate resolution of your claim. So you can always stay and pause it later to continue negotiation or execute a tolling agreement with the customer, with the government, which would suspend the running of that statute of limitations clock. All right, we can go to the next slide, which I believe is code, I think there was supposed to be a code word here. Is that on the next one? For the CLE? Okay, it's not appearing on the slide, but I'm gonna go ahead and tell you all the code word. So, as mentioned at the beginning of the webinar, we need a brief moment to satisfy the CLE requirements by delivering a code word. This is for New York or New Jersey licensed attendees. You must type the code word disputes. That's disputes, disputes, into the Q&A section of your screen. Please make sure to hit the send button so that it registers, we get it. And again, the code word is disputes, like contract disputes. So disputes. And please type that into the, again, into the Q&A section of your screen and hit send so that anyone licensed in New York and New Jersey, we can get that as part of your CLE qualifications. All right, we're gonna move to the next section, which is gonna discuss jurisdictional issues. Our first two cases are related, so we'll go to the next slide. So this AVU case is a federal circuit case that was, it's an appeal from a CBCA decision, so the Civilian Boards of Contract Appeals decision that originally dismissed the contractors or the claimant, so the software licensor, AVU, their claim for a lack of jurisdiction under the CDA on the basis that their end user license agreement did not possess the key characteristics of a procurement contract within the context of the CDA. So just a little background here, AVU, they develop and sell software, but they do not contract directly with federal agencies. Instead, they sell subscriptions through authorized resellers. Here, AVU licenses software that another company, I'm gonna refer to them as the prime contractor, was selling to government agencies under a federal supply schedule contract. So the contract structure is the FDA placed a task order under the prime contractor's supply contract in 2015 for a subscription to AVU software. So the direct contractual relationship was between the prime contractor and FDA through this task order, and the prime contractor and the GSA through their federal supply schedule contract. AVU's ULA, the end user license agreement, also referred to as the MSA, the Master Service Agreement, was incorporated into the schedule contract. And then the MSA also stated that it would be incorporated into any government contract award without requiring signatures. So when the FDA placed a task order under the schedule contract, the end user license agreement, the MSA, was then incorporated into that task order. So in 2016, the FDA chose not to renew the task order, effectively terminating its subscription to AVU software. AVU, upon learning about the non-renewal, they did some factual digging and determined that unrelated to the non-renewal, the FDA was violating its end user license agreement terms, the Intellectual Property Rights and the Trade Secrets Act. That then led to them sending a cease and desist letter. Basically, the FDA was like downloading information from AVU's software, and they believed that that was a violation of their terms. And so they sent a cease and desist letter, and later filed a claim with the FDA's contracting officer, but they didn't, which was denied on the grounds that the FDA's contract was the FDA's contract was with the prime contractor, not AVU, so no privity there of contract. So the contracting officer even suggested that AVU file a pass-through claim through the prime contractor, which is normally what happens with subcontractors, but the prime didn't do that. So AVU appealed to the Civilian Board of Contract Appeals under the CDA. The board initially denied initially dismissed AVU's claim because upon the government's motion to dismiss, recognized that AVU, the board dismissed the case for lack of jurisdiction because it found that the end user license agreement alone was not a procurement contract under the CDA. And because the government did not acquire anything directly from AVU, its agreement was with the prime contractor, and there's no jurisdiction for the board to hear AVU's claims. AVU appealed to the Federal Circuit, and the court vacated and dismissed and remanded the case, holding that AVU's allegation of being a party to a procurement contract was sufficient enough to establish jurisdiction, and whether AVU is actually a contractor under the CDA is a merits issue, not a jurisdictional one. So they sent it back to the board, the CBCA, telling them that they needed to consider, decide on the merits, whether the end user license agreement, to treat as a merits issue the matter of whether AVU has enforceable rights pursuant to the end user license agreement, plus the schedule contract or the task order, which those two are procurement contracts. So it was like, you needed to go into the merits and really establish what's going on here. So let's go to the next case. And we'll do some takeaways from that because they're kind of related. So it went back to the board, and agencies argued that the FDA did not enter into a procurement contract express or implied with AVU by placing an order with the prime contractor under the schedule contract. So the board here again decided that they did not have jurisdiction, but they also, as the Federal Circuit instructed, evaluated the case on the merits, and they both found that AVU failed on the merits because it was not actually a contractor under the prime contract with the FDA or the GSA. AVU is not named in the prime contractors agreements, nor did they sign a contract with either agency. So therefore, they decided they have no enforceable rights under the prime procurement contracts. Next, the board also considered whether AVU had a direct procurement contract with the FDA through the end user license agreement. They determined that the EULA was a contract that was binding on the FDA, but it did not satisfy the definition of a procurement contract, aka it wasn't a contract for procurement of property or services that the board has authority to address under the CDA. And therefore, the board again dismissed it, saying it didn't have jurisdiction because the CDA only covers procurement contracts, and the end user license agreement did not satisfy that. So this kind of shows us for our takeaways that there's still no clear direct jurisdictional pathway for software companies that license their products through contractor or resellers to pursue violations of their end user license agreement through the CDA before the board or the Court of Federal Claims. And if a licensor, just like any other subcontractor, wants to pursue a claim against the agency, the government, it needs to establish CDA jurisdiction by getting the prime contractor to sponsor and certify the claim before they present it to the contracting officer, and then later appealing to the boards. All right. And I think we can advance to the next slide.
Thanks, Megan. So for this HERO case, a DoD employee filed a claim with the Merit Systems Protection Board and challenged a 6-day furlough. And the administrative judge upheld the furlough, and the employee appealed to the board. But because the board had lost its quorum during this time, 5 years went by before the board was actually able to rule on the employee's case. And at the end of the 5-year delay, the board ultimately did affirm the judge's decision. But because the employee's work email had changed and he had never notified the board of his new email address, he unfortunately never received notice of the board's decision, and this led him to failing to timely appeal to the Federal Circuit within a 60-day appeal deadline. The employee requested that the Federal Circuit grant him equitable consideration for his untimeliness, but the court denied his request. The employee's claim made its way all the way to the U.S. Supreme Court, and the High Court held that the requirement to appeal within 60 days was not a jurisdictional issue. And for that reason, equitable exceptions for his untimeliness were not precluded for him. And the court reasoned that a procedural requirement is jurisdictional only if Congress declares it as such. And the language and the statute cited on your screen today supported that the 60-day window was just a filing deadline to promote the orderly progress of litigation. So the key takeaway from this case is that SCOTUS's ruling signals that it really could just be a matter of time before the Federal Circuit does away with the 90-day or 12-month deadlines being a subject matter jurisdictional bar to contractor appeals. And I think that this is especially true if you read this particular Harrow case together with the prior ECC international case at the Federal Circuit, which, as you may all remember, held that the some certain requirement for CDA claims is not jurisdictional. And although this case doesn't mean that contractors should ignore filing deadlines by any means, this case could provide contractors at least a chance of battling the dismissal of untimely appeals if there are facts that support, a reasonable basis for the contractor's untimeliness. Next case, please. So this is Independent Rough Terrain Center. In this federal claims case, the Army issued a solicitation for a follow-on production contract from an earlier other transaction prototype contract. So two companies, IRTC and Taylor Defense, participated in the prototype phase and then submitted proposals for the follow-on production contract. When IRTC submitted its proposal, its SAM registration was active, but that registration lapsed during the evaluation phase before it was ultimately reactivated. The Army awarded the follow-on contract to Taylor Defense, and as you may guess, the IRTC protested. The government ultimately moved to dismiss for lack of jurisdiction. The court held with respect to two issues. One was related to jurisdiction, and the other one was more of a minor issue related to SAM registrations. With respect to jurisdiction, the court denied the government's motion to dismiss and held that the court does have bid protest jurisdiction over follow-on production contracts. The court explained that follow-on production other transactions, OTs, meet the definition of a, quote, procurement under 41 USC section 111. And the reason that is because the production contract was being used to acquire goods and services. And I think this is interesting because it contrasts the court's conclusion in SpaceX, the SpaceX case from 2019, where the court found that the prototype OT was not a procurement contract because it found that it was issued for the provision of general investment and launch services and not necessarily for the acquisition of goods and services, as was the case for this IRTC case. And as for the second issue, the SAM registration issue, the court held that the SAM continuous registration requirement applies to non-FAR-based acquisitions, just like OTs, especially where the solicitation makes it a mandatory requirement. In this case, the protester's failure to continually maintain its SAM registration meant that it was not eligible for the award and therefore did not have standing to protest. Two quick key takeaways from this case. The first is that the court may have jurisdiction over an OT if it seeks to acquire goods and services for the government. The second is offerors should maintain active SAM registrations from the time of submitting the proposal all the way through award, and especially so when the solicitation requires continuous registration. And this concludes our jurisdiction cases. I'll hand it over to Joe to cover bid protest. Thanks.
All right, thanks, Sandra. And a nice transition there, ending with the bid protest case. We could move on to the first slide, please. So this is a case, Percipient AI, that has made the sort of news circuit, been an interesting case for the last sort of year and a half since it was first issued by the Court of Federal Claims. And then here's the Federal Circuit decision that we're going to brief today. And I did want to note this Federal Circuit decision has been vacated or held in abeyance because it is going to go for en banc review. That hasn't happened yet, so we will see what the Federal Circuit ultimately decides. But that alone is a fairly unique procedural posture for a bid protest case. Often they end at GAO, sometimes the Court of Federal Claims. Every once in a while, Federal Circuit en banc is somewhat of a rarity unto itself. And that's because this case really did sort of shake the ground of bid protests. So let me give you a little bit of background. The case was held with started with National Geospatial Intelligence Agency. So this is a federal intelligence agency that does a lot of map making, collects geospatial information. They were looking for a new solution that basically had two components to it. One was for sort of simplicity, a data warehousing, so a data storage component, and then a interface component so that users of their information within the intelligence community could access the data stored on the data platform. The contract was ultimately awarded to Casey to build this system. What starting right out the gate is unique about this, Percipient AI, who is the plaintiff in this case, fully acknowledges they could not be the prime contractor. They do not make a data hardware solution, nor do they invent data hardware solutions. That's not what they do. They have the interface piece commercially and thought that that ought to be incorporated into Casey's work as the prime contractor. So that starting right out is a unique posture. Their contention is we make a commercial solution. We have already the built interface system that Casey, as the government's prime contractor, ought to purchase from us and then incorporate into the ultimate delivery that goes to the government, combine it with the data solution that they're working on, and deliver that to the government. The Court of Federal Claims held that for a couple of different reasons, Percipient lacked standing, and therefore the court lacked jurisdiction to hear this protest, in part because it related to a task order. So for those of you who may be aware, task orders are generally only challenged at the GAO, and that has been a subject to a number of discussions over the last years of exactly what that limitation means and the sort of parameters of that limitation. So that was an issue. And then also, again, this fact that Percipient is never intended to be, could not be the prime contractor, but really wanted to make a commercial sale to the government's prime contractor. And that's not a typical bid protest posture. So the Court of Federal Claims denied the protest. Percipient appealed, which we can move to the next slide, which brought us to the Federal Circuit's decision over this past summer, in which the Federal Circuit held Percipient did have standing, that this was an appropriate bid protest, and that is fairly groundbreaking for a number of reasons. First, the Federal Circuit dealt with the issue of the task order bar. And again, a number of years ago, the Congress revised the statute and said, if you are protesting the award of a task order, first it has to be over a certain dollar threshold, 10 million for civilian contracts, 25, though that's now going up to 35 million for Department of Defense. If it's under that value, you can't protest at all. If it's over that threshold and relates to a task order, you can protest, but only at GAO. You can't go to the Court of Federal Claims. So the Federal Circuit, in reviewing that, said, that does not mean just because it deals with the task order, we are barred from hearing the case. What it means is the protest has to be related to the issuance of a task order. Essentially, an award, a traditional award protest. Hey, I think I should have won that task order, not my competitor who you ill-advisedly awarded the contract to, but that's not what's happening here. The Federal Circuit concluded Percipient is not challenging the award of the task order to Casey. They have no problem with Geospatial Intelligence Agency deciding Casey was their prime contractor. What they are challenging is, in a sense, Casey's decision not to buy their commercial solution, but the way they phrased it was the government is not enforcing the statutory preference for commercial items in its application of this contract. And so that is the deficiency that we are dealing with. So the court next addressed, the Federal Circuit now next looked at and said, okay, so we don't think the task order bar applies. We don't think this is a contract administration issue because Percipient has identified a statute that says you must buy commercial items. They're saying the agency has not followed that statute and they are aggrieved in some way. So we think we have that element of our jurisdiction. And then the third prong was, is Percipient an interested party? And again, the sort of orthodoxy in the bid protest bar has been pretty standard. Interested party means, hey, I should have won that contract, not the other guy. And in this case, again, that didn't apply. The Federal Circuit said that definition of interested party, which dovetails with the GAO's definition of interested party, applies when you're challenging the award of a contract. And that is an element that we share with GAO. But the Court of Federal Claims has an additional element of jurisdiction. It also has jurisdiction over generalized challenges that a procurement, something in connection with the procurement, violated law or regulation, and that's the avenue percipient is viewing. And we don't have a separate definition for interested party, so we are simply going to apply the traditional standing analysis. Was percipient harmed by the agency's failure to enforce the preference for commercial items? And this panel concluded they are. Had the agency forced KC to find a commercial solution for this interface component of the solution they're working on, percipient would at least have been potentially in line to win that as a subcontract, and therefore their economic interests have been harmed. Again, that was quite a new development. It has typically been the view that subcontractors have no standing to bring protests. And again, the Federal Circuit panel to an extent acknowledges that and says, yes, normally a subcontractor doesn't. The issue here is there's a particular statute that this party is saying is not being followed and is harming them. So that was quite a new development, something that would be potentially concerning to our prime contractor friends, large integrators who do buy items from various sources, that this does sort of open up their operation of their main big program and the sources they use to integrate, that if someone comes out and argues you should buy my commercial solution instead of developing your own, that, as the panel decision holds, would have standing to bring that as a bid protest. As I noted, the Federal Circuit en banc is going to take this issue up for review, limited only to that question of interested party. So the Federal Circuit is leaving alone this sort of broader view of task order or broader view of the court's jurisdiction, that just because it pertains to a task order, if it's not actually related to the award of that task order, the bar doesn't apply. So that does open the aperture for cases somewhat pertaining to task orders, but not challenging the award of the task order, to have Court of Federal Claims jurisdiction. That appears to be left open because the panel's not going to review that. What they're really going to focus on is what does it mean to be an interested party and address this unique circumstance of a subcontractor or potential subcontractor or supplier challenging the award. So in a part, we'll have to stay tuned for this, but groundbreaking kind of case that would open up both opportunities for those in the commercial sector, but also might be quite concerning for those friends of ours joining us who are in the more large integrator role in the ecosystem, that this opens up some additional risk. I have already gone over my already abbreviated time, so I'm just going to quickly note the two following protest slides that we were going to brief. One is, so you can move to the next slide, please, is Oak Grove. Interesting piece here, as Phil kind of noted and already spoke to. Ultimately, the Federal Circuit here, one of the issues that was raised was a failure to hold discussions. There's a DFARS clause that says the government will hold discussions in certain circumstances. The solicitation said, we're not going to hold discussions. And the Federal Circuit said that was a patent ambiguity. If you thought they weren't following the law in the way they were going to conduct discussions, you knew that, you should have protested it at the outset. So I think consistent with the theme that the courts are pushing a lot more to this, you should have known and should have protested earlier. You have always been able to file pre-award protests, so I just don't like solicitation terms, but a lot of cases, both in the claims side that we talked about, as well as some of the other protests, saying those may need to come much earlier and be styled as award protests. And if we can skip to the next slide and advance past that one as well, just to give you a quick Reader's Digest version, HPI Fed LLC, a GAO decision enforcing TAA or Buy America, this is an exception to Buy America, Trade Agreements Act compliance, that if those are not properly supported at the bid stage, that is something that is ripe for protest. So policing whether your competitor and competitors policing your company's compliance with TAA presumably would also apply to Buy America and other domestic preferences, is something that can be pursued through protests. So I know I took more than I took my original amount of time, but not the abbreviated time. So I do apologize for that. Let me turn it over quickly to Morgan, and sorry for running long.
So I'm going to briefly give the closing comments about the CLE webinar piece. And then in the interest of time and recognizing that we are at 11, if you'd like to log off after that, you're welcome to. For the interest of just the full education, though, that's associated with this, we have 3 more slides that I am going to present on. They'll be available in the recording if you're interested, or you can stick on. So thank you again for participating in today's webinar. In approximately 30 business days, you will receive an email with a link to your CLE certificate. Your webinar login details will be used to process these certificates. No additional steps are required. As a reminder, the code word requirement is only if you are seeking credit in New York or New Jersey. So thank you so much. If you'd like to stay on, you may. Otherwise, we'd reference you to the recording, or you can also go to dentons.com. And if you go to the knowledge tab, we have some published alerts as well on some of these cases. So I'll let folks filter out if they'd like to. And then Nick, if you'd like to go to the next slide, that would be wonderful. Could be a case Nebraska v. Sioux that should be popping up. I'm not sure if others can see it or not. Yes. All right, so if you can go to the next slide. So this case here, it's Nebraska v. Sioux. And this is out of the 9th Circuit. You may be wondering why Nebraska and why we're in the 9th Circuit. It is because the Attorney General Raul Labrador out of Idaho actually is one of these states that is leading the case here. And so this is in reference to President Biden's executive order 14026, which addressed a raise to the federal minimum wage. In 2021, it raised it to $15. We've actually recently seen an additional increase to $17.75 per hour. So this executive order is still in place, and we currently have a circuit split. So we have the 9th, the 6th, and the 11th on one side of the aisle, finding that the president and relying upon FPASA, the Federal Property and Administrative Services Act, that issuing this mandatory minimum wage goes beyond their executive power and the presidential authority that they have. On the flip side of that, we have the 10th Circuit, which reached this concept of a nexus standard, and they actually sustained the former president's authority to issue this minimum wage executive order. And so what's interesting about this case is that we have on the one side, we have some circuits that have said that this is an overextension of presidential authority. On the other side of that, we've said that this may be a permissible exercise of presidential authority. So the 9th Circuit case that we have here in Nebraska v. Sioux, there was a filing in this case for a rehearing with the entire 9th Circuit. Originally, it was a divided 3-judge panel. And so it remains to be seen whether the Supreme Court will take up one of these cases and whether or not they will reach this issue, or if in the alternative, President Trump makes the decision that he no longer wants to enforce his executive order. Notably, we're already into March and he hasn't done anything on this, so it remains to be seen what will be done there. But the key takeaway here is that the Trump administration currently is using these cases to actively defend its predecessor's executive order and to advance these broader arguments about the president's authority to regulate, which is an interesting commentary because you have, on the one hand, a policy that may not seem in line with what this administration would traditionally work with. But on the other hand, you see an executive order and some case law that is expanding presidential authority as it relates to the ability to act versus agency action. And so there's kind of an interesting contention that exists there. Next slide. And then next slide. So this is going to be agency discretion. We have Loper Bright Enterprises. And this case is dealing with the Magnuson-Stevens Fishery Conservation and Management Act. This is one of 2 cases that actually dealt with this. There's another one, Relentless, and both deal with this requirement to have individuals who are able to essentially observe the fishing practices that are occurring for these lovely, lovely Atlantic herrings. The cost was about $710 per day, and if there wasn't federal funding, these fishermen were required to provide payment for these observers. And ultimately what this case does, and why it's very important for anyone who's been to law school in the past 40 years, is this gets rid of the longstanding Chevron doctrine, which established a two-step framework. And as part of that framework, you may be familiar, courts determine whether Congress has directly spoken to the precise question at issue. So you're looking back at that legislative history. And if not, the statute, if it is ambiguous, the courts were deferring to the agency's interpretation as long as it was permissible. And the idea behind that was that agencies are experts in their field and they have the requisite knowledge. If we can go to the next slide. Ultimately, when the court decides to overturn Chevron, and this has been a long time coming, if you've been tracking on this, there have been a lot of judges asking for a review of Chevron. You see Chief Justice Roberts invoking the history of the federal courts and this underlying notion essentially that the final interpretation of laws is the proper and peculiar province of the courts, quoting Alexander Hamilton. And it's essentially bringing back to focus this idea that the courts are actually the ultimate arbiters of this question of ambiguity, as opposed to the agency's ability to. And why this is relevant for contractors is if you are facing burdensome regulations, you may have some stronger legal grounds now to challenge them. The remaining deference framework that remains in effect is regulatory, and there's still deference in effect, and that's Skidmore deference. So if we can go to the next slide. We will close out with Boeing. And so the Boeing case, in it, the contractor makes 8 cost accounting changes. 2 increase the costs, 6 are neutral or end up ultimately decreasing the costs. And ultimately, Boeing asserts that there's a savings of $1.5 million. The government decides, in fact, actually, that we're going to demand payment on these claims. We don't agree with this kind of aggregation position. Boeing challenges this, and there's a lot of back and forth on this, a lot of jurisdictional back and forth between the Court of Federal Claims and the Federal Circuit. If you've been watching this, it's been going on for a number of years. But ultimately, what happens is after the Federal Circuit sends it back to the Court of Federal Claims, it ends up going back to the Federal Circuit. And the takeaway from this here, and I think there should be another slide, if you can go to the next slide, that although the Court of Federal Claims does not have this jurisdiction to decide pure challenges to the validity of regulations, it still has jurisdiction if the true nature of the action is contractual. And Boeing has 3 contractual claims and only argues in the alternative that 4th claim, which the courts discuss, has jurisdiction under the Tucker Act 1491A1. And the key takeaway here is that the holding in Loper-Bright, coupled with Boeing, may open the door for broader and potentially more efficient mechanisms to challenge the validity of regulations. This is a complex case. So again, if you are interested, we do have a publication on our website that goes through in more detail the what happened with this case and kind of some of the implications for contractors. So that's everything. Thank you if you did decide to remain on, and I hope you all enjoyed this presentation.